Yep. Good afternoon, everybody. I'm Brandon Putz. I'm with the Crane Agency, and we're going to talk today about sexual harassment for supervisors. So I've actually given this training before at a client that actually had an allegation of sexual harassment against one of their supervisors. And after that happened, they wanted me to come in and do a little bit of training, get them updated on what sexual harassment is and what you can do to prevent some incidents and what you can do to prevent potential lawsuits. So we're going to start today. We're going to talk about harassment, but if you take sexual harassment, you break it down, and you think of harassment, what do you think of it as? A lot of people think of harassment as you irritate or torment or to persistently or wear out and exhaust. And that's kind of what people think of when they think that somebody's harassing them or when they think of harassment in general. But can anybody think of maybe a problem with this definition as it involves sexual harassment? Is that with sexual harassment, it's going to be a little bit different. It can be, you can wear somebody out, but also if that sexual harassment event is severe enough, even if it's a one-time event, that can cause problems and that can also cause lawsuits. So there's a legal definition of sexual harassment. Here it is. Basically what it boils down to is that you're creating a poor or bad environment for somebody. And this is caused by the behaviors of employees or other people in the workplace. The legal definition: unwelcome advances, requests for favors, other conduct. And what this ends up happening is that this conduct is of a sexual nature, and it's going to affect that individual's employment in some way. So it can create either a hostile environment, or maybe there's a quid pro quo situation, which we're going to talk about. But this situation just makes it a difficult environment for an employee to work in. So let me see. So some of the facts about sexual harassment, some of these people know, some you may not know, but the victim as well as the harasser may be a man or a woman. So it doesn't matter who the victim is, or what the sex of the victim is, what the sex of the perpetrator is. Anybody could be the victim or they could be the harasser. It doesn't matter. I think that we most think of the man as being the harasser, the woman the victim, but it doesn't always have to be that way. Another thing that so many people may not realize is that the harasser can be the supervisor, an agent of the employer, a supervisor in another area, a coworker, and something that people don't realize, even a non-employee. So if you think of that, you think of, well, what's a non-employee that could, sexually, be involved in a sexual harassment incident? But if you're in construction, you're in a multi-employer site, or if you even have a vendor come into one of your businesses, they could potentially be one of the perpetrators of sexual harassment. And if they are, you have to protect your employees against that. The victim does not have to be the person harassed, but could be anyone affected by the offensive conduct. This is another area where people get in trouble. They may hear two people having a conversation, and the two people aren't offended by it, but there might be a third person involved that overheard what those people said, and they're offended by it. If you're a manager or supervisor at your business, you have a unique role to prevent and address sexual harassment, both for individual incidents and in the work environment. So if you do see or you're witness to or a part of a sexual harassment incident, you actually have a duty to investigate that further and provide a safe and effective work environment for your employees. So don't think that you can ignore it. The law says that if a supervisor knows about it, your whole business knows about it. There may be some economic injury involved to the victim, but there may not be. But if there's a hostile work environment, it doesn't matter. The person could still have their job. But if that work environment is not a harassment-free work environment, you can be legally liable for it. So besides being civilly liable, if anybody's heard of Title VII before, but if your company is violating Title VII by not having a harassment-free work environment, you can get a complaint to the EEOC and you can be under investigation by the federal government. The harasser's conduct must be unwelcome, so we'll talk about that a little bit more. Welcome context doesn't necessarily, if the conduct is welcome, it doesn't necessarily rise to the level of sexual harassment, but there are other issues also that you have to think about. The employer is always liable for harassment by a supervisor that results in an intangible employment action. So keep that in mind. The people that are working under your company, whether employees or managers, you're going to be liable as a business owner for their conduct. So you can't just assume that, well, that's just how that person is. Anything that they do, you could be potentially liable for as a company. All right, there's some elements of a sexual harassment claim. It's unwelcome conduct of a sexual nature. It can result in a tangible employment action or create a hostile work environment. We talk about tangible employment action. There could be a lot of things in that. A tangible employment action means it's affecting their employment in some way, whether or not maybe the person is not getting a promotion or getting a promotion based on conduct that they agree or not agree to of a sexual nature. Or there's a legal basis upon which to hold the employer liable. Does the employer have the duty and responsibility to create a harassment-free workplace? And the answer to that is yes. So you get down to the two types of sexual harassment. When you break it down, you have quid pro quo and you have hostile environment. Quid pro quo is a Latin term meaning this for that. So the legal terms are often in Latin, but the concept is simple. This for that, so it's an agreement. It's usually a supervisor requests potential sexual favors for somebody else, and it's going to result in what's called a tangible employment action. So perhaps the sexual conduct is going to be rewarded with a promotion, or perhaps there's even implied that somebody will be demoted or fired if they don't agree to that sexual conduct. Most people would agree that that would sexual harassment, and that's not really controversial. Where it gets difficult and where there are a lot of legal issues and a lot of gray areas are the hostile work environment claims, and we'll get into that. Going back to quid pro quo, these situations occur when an individual's submission or rejections of unwelcome sexual contact is used as the basis of employment decisions affecting the individual. If anybody can think of some people that are in the news right now, and maybe a quid pro quo situation that I can think of would be a Harvey Weinstein situation, where he's kind of basically implying through his conduct that submission to his advances is going to help your Hollywood career. And that's how Harvey Weinstein got in trouble with a quid pro quo situation. So what's some behavior? You can promise hiring, firing, promotions, awards, transfers, disciplinary action. If any of these are based on somebody submitting to your sexual advances, that's quid pro quo. What are some typical examples? Supervisor coerces an employee into a relationship and then rewards the employee. Or maybe kind of the reverse of that. Supervisor takes disciplinary action or denies a promotion to an employee because he or she rejected the advances. Where we get a little bit trickier, where it's a little bit more nuanced, is the hostile work environment. So what is the hostile work environment? Hostile work environment happens when there's behavior in that person's job or in the environment of their job, And it's basically creating an offensive work environment. So as a business owner, as an employer, you have the responsibility of providing a work environment where that person can thrive and they're free of harassment. If you don't provide that type of environment, you can be legally liable for what happens. This form of harassment can constitute discrimination, even if there are no tangible job consequences. So a lot of people see a situation maybe where a supervisor is harassing an employee, that employee still has their job, that supervisor still has their job. So what are the economic consequences? Can they sue for? Well, you can still be sued for having a hostile work environment, regardless of whether or not anybody loses their job. So what are some typical hostile environment type issues that you might see at your workplace? These are ones that I see a lot. Displaying pinup calendars or sexually demeaning pictures. I've gone to a lot of different work sites before. I've gone to a lot of warehouses. I've gone to a lot of what you might call blue-collar work environments. And what you will see is a lot of pinup calendars. Can that cause a hostile work environment claim? Potentially, yeah. So I always tell people to take those pinup calendars down. Why? Because somebody might find it offensive. Somebody finds it offensive, you're creating a hostile work environment. Making sexually oriented jokes or offensive remarks. A lot of times you'll have two people and they'll be in a conversation, they'll maybe make a sexually explicit joke. Neither of those two people find it offensive, they find it funny. But it doesn't mean that there's not somebody else that may have overheard that joke and they thought it was offensive. And therefore, in their mind, they're working in a hostile work environment. You got to be careful. Subjecting another employee to unwelcome sexual advances or touching. I think that's not very controversial. Somebody that's what you might call touchy-feely or is just constantly touching people in a way that makes people feel uncomfortable can create a hostile work environment. Anybody in the workplace may create a hostile work environment. We think of the supervisor and the employee, but that harassment can also come from a fellow coworker. And it can also come from a non-employee. This can include if your employees are working with the public, this can include a guest, maybe another contractor if you're a construction company in a multi-employer site. Or even an outside vendor can come in. If that outside vendor is somehow harassing your employee, you're responsible for that as an employee, and you're responsible for investigating that and preventing it. I think it goes without saying that your intentions don't matter if a person feels harassed or humiliated. I think a lot of people will try and defend themselves if they are accused of harassment, and they'll say, I didn't intend to offend that person. But while that may be true, it's not really a defense against a sexual harassment claim, okay? You have to think about what a reasonable person would be offended by, and you have to conduct yourself, especially in a business setting, in a way that is not going to offend somebody. Different people have different reactions to the same behavior. Like I said, if it's just because you don't find the conduct offensive, your friends don't find the conduct offensive, that doesn't mean that there's not a third party that will. So you always have to keep in mind how other people are going to perceive your actions, because different people have different reactions. And it's not just what you say. It can be verbal written, so comments about clothing or the body, innuendos. I grew up in the 90s, so what was the big thing? That was email forwards, jokes, telling rumors about a person's sex life. Sending lewd emails and now text messages are a big thing. These can all be part of a hostile work environment claim. And I think a lot of people get in trouble too with the emails. What do we know about emails now? You might as well just consider them a matter of public record, okay? They're not private. Anybody can go in and investigate emails, and basically it's going to have a complete record. There's a complete record out there of every email that you've sent from a business standpoint. And then also sexual harassment can be physical, so we're talking blocking movement, inappropriate touching. Like I told you, that maybe that person's a little too touchy-feely. That for the work environment. Inappropriate kissing, hugging, patting, stroking. If you notice any of your employees doing this and you notice that the person they're doing it to is not comfortable or they're recoiling, that's something that you need to investigate, because that can be considered part of a hostile work environment claim. Doesn't necessarily even have to be verbal, okay? Ogling, looking up and down somebody's body. You can use your eyes to convey a lot of information. Posters, drawing pictures, screensavers, all that of a sexual nature should not be in the workplace. And also, sexual harassment, it can actually be non-sexual in nature, sometimes. If you think of maybe a industry that has, that's maybe 95% males, take construction for instance, and those men are picking maybe on the one female construction employee, that could also be grounds for a hostile work environment claim, even though the conduct wasn't necessarily sexual in nature. So if you're an owner, you're a supervisor, it's your professional responsibility to keep the workplace harassment free. It's not anybody else's responsibility. Nobody else is going to do it. And you can't adopt a kind of a boys will be boys type of thought process on that. We recommend a zero tolerance policy for unprofessional conduct. And there's a lot of different definitions of zero tolerance, but I would say a zero tolerance policy on sexual harassment means if you see something, you have to do something about it. You have to follow up on it in some way. You can't just let it go. It's your obligation to address all suspected unprofessional conduct and report that harassment to the appropriate management. So if you are the manager, it's your responsibility to either investigate it or report it to somebody who can investigate it, like an HR professional. And it's the supervisors that are kind of given the role of ensuring the integrity and fairness of the workplace. The workplace is supposed to be harassment-free. Anybody's supposed to be able to thrive there. So it's the supervisors that have the responsibility to prevent and investigate any harassment that they know about. And if they do know about harassment, like I said, as far as the law looks at it, even if they don't report it, if a supervisor knows about it, they don't report it, maybe to a higher supervisor or even to the owner, that's going to be a problem, because if the supervisor knows about it, the law says the company knows about it. And the supervisor has a responsibility to prevent the harassment if they can and investigate it, or maybe forward it to somebody who can investigate it. So what the supervisor is going to have to do is investigate it themselves, or if there's a more formal investigative process, to forward it to somebody that can. And prevention is the best tool to eliminate sexual harassment in the workplace. Unfortunately, there's just all too many companies out there that are reactive instead of proactive. And I think of reactive, I think who's been in the news lately? Starbucks, right? Did they have proactive training, racial bias training? Did they do that before they had a major incident, or did they do it after they had one? They waited until the major incident happened, and now they're being proactive, or they're being reactive, not proactive. You want to be proactive. So what can you have in place so you don't have the big blow up? Definitely have an anti-harassment policy. Definitely have a written policy. A zero tolerance policy on harassment. Educate and train employees. I always recommend that you do some kind of training on sexual harassment, whether it's mentioning it in your orientation, maybe an online training, somebody talking to your employees. Because if you do have an allegation of sexual harassment and you don't have a written policy and you don't train your employees, what's the jury going to think? They're going to think that you didn't do anything about it. You weren't being proactive. You should monitor enforcement of the anti-harassment policy, and of course you need to investigate all allegations of sexual harassment. I recommend, if you can, that those investigations are done by a HR professional or somebody that knows how to investigate these claims without encountering all the many problems that there are going to be. Investigating sexual harassment claims, it can be a very difficult process. And why is it difficult? Well, there's a lot of things that you have to worry about when you're investigating a sexual harassment incident. You're going to have to protect an individual's confidentiality, and that can be quite difficult if that person is making an accusation. You're going to have to be very careful what you say. You can't retaliate against somebody for making a sexual harassment allegation, even if you suspect that it's frivolous or not true. You need to have documented corrective action taken, and you need to document top to bottom all your investigative results. And that's why it can be difficult for a non-trained or another individual that's not really familiar with the process to investigate. All these things you have to keep in mind. How do you protect yourself? Well, there are potential remedies to a sexual harassment claim. Oral or written warning or reprimand. So if somebody is accused of sexual harassment, you're going to want to have some documentation in place saying that this person was reprimanded or somehow disciplined for their action. Some other things that you can do, training or counseling a harasser so they understand why their conduct violated them or any harassment policy. That's kind of what the mode that Starbucks is in right now, and they're trying to protect themselves legally as well. Monitoring of harasser to ensure that the harassment stops, I think that's important. If somebody is a lot of times when somebody makes an accusation, in my experience, this conduct has been going on for a long time. And it just so happens that somebody decided to step forward and make a formal complaint. So if that conduct and that employee's been around for a long time, you're going to want to make sure that not only did you reprimand that employee, you want to make sure that that conduct stops. So you might want to be questioning your employees to make sure that that conduct has been stopped. Transfer, reassignment, or discharge, all of these are potential remedies. I think the important thing is it all depends on the situation and how severe it was as far as what you're going to do. Okay, and this is what we tell employees if they're harassed, and this is the kind of the situation, this is what you should do. If they are feeling if that conduct does offend them, they really do need to say no clearly, document the harassment, and contact the HR department. But if your employees don't know about this, they don't know that you have a system set up to investigate sexual harassment claims, what happens? They stay silent. They don't talk about it. And these things can build for years and years, and that's how we have the Me Too movement. Women are now stepping forward and saying, me too, I was harassed as well, and we're not going to take it anymore. So Jerry's going to get into more, but I'm kind of giving the basics, but in summary, what is sexual harassment? It includes any action of clear or potentially sexually motivated nature. Your words or actions can arise to sexual harassment if they are unwelcome or they're linked to employment decisions and form the basis of such decisions. It's against the law. It should not be tolerated. It violates the EEOC. So not only can you get a potential lawsuit, but federal government can come in and investigate an Equal Opportunity Employment Commission will come in and they could potentially investigate the complaint. So now you have an EEOC investigation going on at the same time as a lawsuit. You don't want that to happen. The EEOC is going to request information such as what's your sexual harassment policy, what are your disciplinary actions. If you don't have those in place, there could potentially be fines. All right, so I developed a little bit of quiz. So if anybody wants to jump in with an answer. I think some of these are pretty straightforward. Can a man be sexually harassed? Does it have to be a woman that's sexually harassed? Can it be a man? That is correct. Doesn't matter. Both men and women can be the victims and perpetrators. So guess what? The same rules apply to men and women. True or false? This is a little tricky. A welcome advance is sexual harassment. Yes or no? True or false? Okay, false. I mean, sexual harassment by its definition must be unwelcome. But guess what? Does that person know ahead of time whether or not that advance is going to be welcome or not? They don't know. So it can be very tricky. But if the advance is welcome, it's not technically sexual harassment, but it's also could potentially lead to a sexual harassment claim. Okay, well, I think this one's pretty straightforward, so we won't get into it too much. And this happens, and this used to happen a lot. A man would claim that maybe the victim dressed in a sexually attractive manner, and therefore it was okay to do whatever or to say whatever he said. Absolutely not, though. The harasser is always responsible for the harassment, regardless of the victim's behavior, judgment, or previous actions. So keep that in mind. A coworker comes up to you and makes a sexually explicit joke. It doesn't offend you. Is this sexual harassment? Kind of a tricky one. I would say maybe. Because what if a coworker or a third party heard the joke and that offended them? They can potentially claim that that's part of a hostile work environment. They shouldn't have to go to work and have to hear jokes that offend them in that manner. And here's where we get to another really tricky situation. I'm sure Jerry can enlighten us on some of these dating people from work scenarios. But we can go over it just briefly in this one question. Is it illegal to date somebody for work? Yes or no? Okay. I wouldn't say it's illegal, but there's a lot of issues that can happen. Usually, the dating between non-supervisory employees, it's probably not going to cause as many legal issues, though there can be awkward situations that occur. But if you have dating going on between a supervisor and a non-supervisory employee, well, that's where you're going to get into trouble, because it can easily lead to implications that the supervisor is playing favorites. And a hostile work environment claim can spin off from that. But also, the supervisor's they're not in a position, any actions they take, if they don't promote that employee, they could get in trouble. But if they punish that employee, they're going to get in trouble. So it leads to situations in which the legal liability just shoots right through the roof. So think about that if you have to encounter any situations in which there's a supervisor and an employee dating, and that supervisor actually has supervisory responsibilities for that employee. Okay, that's a very high hazard legal situation. I think I covered this very first thing. It's only sexual harassment if the harassing actions are repeated. True or false? And that's going to be false, okay? They can be repeated, and that can be the basis of a hostile work environment claim. But if a single incident is particularly egregious, or maybe one or two incidents, that can be sexual harassment. We think of maybe somebody that was accused of a couple incidents, but they were severe. I would think of Matt Lauer, because that's the situation he was in, where he had worked for 20 years on the Today Show, but a couple accusations that were sufficiently severe ended his career. And upon investigation, it seems like there was some basis for those allegations. I accidentally clicked it, but sexual harassment can occur without anyone saying a word. True or false? This can be true, okay? You don't have to, you have to think of not just what you say, but what your body language is, and also the written communications that are going out there. These can all be the basis of a claim. All right, does anybody have any questions that me or maybe Jerry could answer? Jerry's going to get up here and do his thing, but if anybody has any questions, I'll see if I can answer them. None? Okay, well, without further ado, Jerry.
Just as a reminder, I'm Jerry Richardson. I've been practicing law since before there was sexual harassment. So I guess that tells you a little bit about my age and how long I've done this. Sexual harassment actually became part of the law in 1980. So you have Title VII of the Civil Rights Act was passed in 1964. Title VII prohibits discrimination on the basis of race, sex, color, national origin, and religion. We've added other things like age discrimination, disability discrimination, genetic information discrimination. All that came later, but from 64 until 1980, there weren't really any sexual harassment claims. The EEOC developed by regulation the theory of sexual harassment. Eventually, courts said the EEOC was right in its interpretation of the law. But that was after years of battling in court. So here we are now looking at 1980, about 37 years, and there's been all kinds of things going on. And so a lot of what I'll talk about today is on the prevention side. And the EEOC, before we got to all this Me Too, did an evaluation, because it had been, at that point, 35 years. They said sexual harassment hasn't gone away. You would think that if this law was effective in that amount of time, it would go away. And so there was a commission that the EEOC put together, and they used not only the evidence gathered by the EEOC in its own investigations, and it collects reams of data. Those of you that complete EEO1s know a little bit about what I'm talking about. But they also went to social scientists. And so some of what I'll share with you is based on what the social science has shown. And then if those conditions are present, well, what do you do to effectively undermine those situations and create a better workforce? So let's think just in the past 2 years, some names that we've all heard, and they may or may not be sexual harassment, because sometimes they're outside of the workplace. But I think the Me Too movement is a bit broader than just the workplace. But of course, we have Donald Trump. We have the Access Hollywood video remarks. If those remarks were made in the workplace, that would be sexual harassment. No ifs, ands, or buts about it. There were 19 women that accused him of some form of sexual misconduct during the election. We have Roger Ailes, who was the president of Fox News until July 2016. There were more than 20 female accusers against Roger Ailes, and he had one of those that settled for $40 million. There was a anchor, Gretchen Carlson, she got $40 million to settle her claim. There are 19 others that most likely were settled, and we don't know exactly how much Fox News spent on those. Then there was Bill O'Reilly. There were at least 6 settlements of sexual harassment claims. Definitely these were things that occurred in the workplace. And the settlement payments exceeded $45 million. I mean, eventually these start showing up as footnotes in financial statements because they're material to the financial performance of Fox News. That's how we learn it. We learn it more through the SEC than we do through the EEOC or a state equivalent like the Missouri Commission on Human Rights in these instances. Then we have Bill Cosby. At least 50 women have accused him of various forms of sexual misconduct. Harvey Weinstein, of course, in October of 2017, that's when that hit. There were over 80 women who made allegations that ranged from rape, sexual assault, and then on the minor side, just sexual harassment. Charlie Rose, another. Charlie Rose, both CBS and PBS terminated their relationships with him because of the way the entertainment business works. He had his own production company, and he was kind of an independent contractor, but the people that were working for him didn't have anywhere to go but him, so then they started going to CBS and PBS, and that led to Charlie Rose's problems. And finally, as Brandon mentioned, Matt Lauer, on November 29th, 2017, NBC News terminated his employment, and the precipitating incident had been a female employee who made allegations that he made unwelcome sexual advances to her during the 2014 Winter Olympics. Now technically 3 years, the statute of limitations had long run on that. It didn't make any difference, and it can't make any difference to particularly employers that have, you're trying to attract a vast audience. Half of your audience is female. You really can't afford to have these kinds of things going on when half your audience is females. In addition, NBC added in its statement about its termination of Mr. Lauer that it had reason to believe that other incidents had also occurred. The way, particularly in this entertainment business, it seems to go, yeah, where there's smoke, there's lots of fire, and they do usually have major problems. Let's take a little bit a look on the next slide with what the EEOC does. In an average year, the EEOC will get about 90,000 complaints. They're called employment discrimination charges. For fiscal year 2017, that ended last September 30th, the total number of charges filed were just about 85,000, so they were down a little bit. Of those, 25,605 alleged sex discrimination claims, and of the sexual discrimination claims, 12,428 alleged sexual harassment claims. That was right about 15% of the EEOC charges. So about 1/3 of all the charges filed alleged unlawful workplace harassment because, as I said, Title VII prohibits discrimination on the basis of race, religion, national origin, color. If there is harassment that is motivated by an employee's color or race or religion or national origin or a combination of those things, those would fall into the broader category at the EEOC of harassment charges. There's also, because of what's happened since the last 6 months or so, been some polling done to see. ABC News and the Washington Post did a poll late last year, and they wanted to assess the prevalence of sexual harassment in the workplace. 54% of women have personally experienced unwelcome sexual harassment, according to this poll. And it was a scientifically conducted poll. No, they didn't ask every single woman who works in America, but you can use a much smaller number, say 2,000 people that are randomly drawn, and you'll get the results that are accurate. 30% of female workers have had male coworkers make unwelcome sexual advances towards them, and 23% of women in the workplace have endured unwelcome sexual advances. from men that had influence over their position, typically supervisory, not always. Now, like a black swan, employees that experience workplace sexual harassment seldom either report their harassment internally through whatever method management has developed for the reporting of sexual harassment claims, or file a formal complaint with an agency. In this state, it would either be the Missouri Commission on Human Rights or with the EEOC. You go to either agency and you'll end up with what's called a jointly filed charge. And both of those agencies have jurisdiction, and usually there's only one investigation. If you go to the Missouri Commission on Human Rights, that's the agency that typically does the investigation. If you go to the EEOC, then that's the agency that typically does the investigation. And generally, the other agency defers, so whatever result happens at the investigating agency, you get a Me Too follow along from the either federal or state agency. Now, get myself lost here. When we look at the complaints, generally instead of bringing complaints, the behavior of the people who are suffering we can call them the victim. I don't like to call it victimhood necessarily. Some complaints are valid, some are invalid. But the people that aren't bringing complaints, but have experienced the conduct, to themselves usually deny the seriousness of the situation. Their way of handling it is ignoring it, trying to forget it, and enduring the behavior. 3 or 4 of these workers never talk to a supervisor, manager, or union representative about the harassment. They do nothing because they fear disbelief of their complaints, inaction on it by management, blame, the old blame the victim routine, or social or professional retaliation. And that's from the EEOC task force. Oh, incidentally, I don't see anyone taking notes, that's great. Anyone that wants my presentation, I will, if you give me a card, I will email it to you. You'll not only get my pretty slides, but you will have my notes. It will be in note format in a PDF file. So all this information and some of the footnotes, like if you actually want to see the EEOC's 90-page study, there's a link to that in my presentation. Now, employers have faced significant direct and indirect costs from workplace harassment. In fiscal year 2015 alone, the EEOC recovered $164.5 million for workers alleging harassment claims. Private party litigation further augments. There's no way to gather how much private parties. Most of the action in this area is not brought by the EEOC or the Missouri Commission on Human Rights, at least in terms of litigation. It's by private parties suing. And there's just no way to get all those results. Frequently, 90-some percent, say 95% even, of the lawsuits filed in this country that involve civil litigation, and that's what these kind of claims are, will settle at some point. And I would say 100% of the settlements require confidentiality. So you just never get access to the information as to how much money was paid to settle those claims. Incidentally, what Congress did last year in that tax legislation that had enormous business tax cuts, and then it had some tax cuts for individuals, and I'm not here to talk about that, other than there is a provision that says if there is a non-disclosure requirement in a settlement agreement, at least if it is for a sexual harassment case, then the paying party cannot deduct the cost of the settlement as a business expense. Well, that's a big difference because all these big, when Fox News pays out $40 million for Roger Ailes, it's a business expense. They just deduct it. So we'll see whether that changes the overwhelming use of non-disclosure agreements and settlements. And I'm someone that writes them all the time. So I know that they're in there, and employers say, well, I don't want everybody and his or her brother alleging a claim, so I don't want anyone discussing it. Well, employers are going to have to make some decisions as to whether that non-disclosure obligation on the person settling the claim is as important as the tax deduction for spending the amount. Perhaps if you have EPLI and it's being paid by the insurer and you're an employer, you don't care. But if we want to look at what can happen in an individual case, I informally keep track of jury trial results throughout the state of Missouri, and that's to help me when I'm working with clients and, you know, what is a good deal for a settlement? What's the likelihood you'll win or lose? Incidentally, at least before the amendments to the Missouri Human Rights Act that took effect last August, if employers went to trial, they lost 62% of the time. And it was ugly when they lost. And there was some really bad law made by decisions to litigate that then went on appeal, and then we got appellate decisions that really made the law worse than it had been. But in any case, if we take one of the worst results from a sexual harassment claim, it happened in 2011 in Jackson County, on the other side of the state where Kansas City is, and the verdict in a hostile work environment sexual harassment case awarded $592,000 in actual damages. Most of that would be, in this kind of case, emotional distress. In this particular case, the employer was a securities firm, and the plaintiff was someone who wasn't just a stockbroker, was higher up in the office, but wasn't the biggest person there. So there's probably some lost wages, but there'd be hundreds of thousands of dollars in emotional distress. She lost her job, I think, as part of her involvement in bringing forward her claims as well. So the actual damages would cover that. And there were $10 million awarded in punitive damages. The attorney's fee alone, under these statutes, Title VII or the Missouri Human Rights Act, if an employee wins, then the employer must pay the employee's attorney's fees. So the attorney's fees for the employee were $666,401, and then there were costs associated with court costs, things like depositions, and if you put fancy videos together and play them in court, $102,000. That's pretty expensive for any case, $102,000 in costs. But anyway, that's when things go south, they go south in a pretty big way. Now, move on to the next one. Some regularly occurring situations present discernible risk factors for sexual harassment. And what the EEOC's task force did is it identified, it's about 10 or 12 of them, and said these are where sexual harassment tends to happen more often than in other workplaces. And the factors involve organizational conditions that may increase the likelihood of sexual harassment. Most workplaces will have maybe not all 10 or 12 of these because we're about to review them, but we'll have some of them present in at least some parts of the workforce. And employers should devote heightened attention to the areas that present the high risk factors in their business. All right, the first high risk factor is homogeneous workforces. And a homogeneous workforce would be one like a predominantly male workforce. I think Brandon was mentioning construction. There's, at least in this area, the female representation in union represented trade jobs is a little bit less than 6%. So that means that on at least the big commercial construction jobs, you're looking at a male workforce typically of about 95%. The only female or one of a handful of females in a predominantly workforce may feel or actually be isolated from her male coworkers. Males perceive such a female coworker to be vulnerable and to exert pressure on her. In some instances, males may alternatively view an isolated female as different or other and to be a threat. Male workers may fear that their jobs are at risk, or that workplace culture may change, or that they may experience anxiety around others not like them. A fine example of this kind of workforce occurred in a case before the Eighth Circuit. That's the United States Court of Appeals. It hears cases from Missouri, Iowa, Minnesota, and I think South Dakota. But in any case, it involved a volunteer fire protection district, and all of the equipment was sized for men. And there were two women that were then brought into the force, and nothing fit them. And this is a matter of safety on the job. And when they brought that to the attention of those who were responsible for the management of the fire protection district, they said, well, that's the equipment we have, you'll have to make do. Well, ultimately, that ended up as a lawsuit, and there ended up being a trial. And there were two plaintiffs, and forgive me if I don't remember the exact numbers, but it was somewhere between $500,000 and $1 million in damages. And the fire protection district had to change its equipment and buy equipment that was properly fitted to the female employees. And it also had to put a female restroom in the firehouse, which it didn't have. Sometimes decision makers make kind of boneheaded decisions that if you step back, you look at, why would you decide to do it that way? But in any case, that's what some of these situations are. Our next situation is if you have women who are kind of breaking barriers, maybe they're overcoming the glass ceiling where they work in a particular workforce, where a minority of workers such as females join a workforce in which males predominate, they frequently challenge the stereotypes that have created workplace norms. A female worker may challenge gender norms by being tough enough to do the job traditionally done by men. Now, you can also face this with a situation of an effeminate male working in a predominantly male workplace. In fact, the case went to the US Supreme Court, the on-call case, and it was against a Sundowner oil company. They were out on a platform in the Gulf. It's an all-male workforce. But the effeminate male was singled out by the rest of the work crew, and he was, as they called it in the case, they bagged him, which apparently meant they goosed him. And they did it quite a bit. And he ended up bringing this lawsuit, and that's where Justice Scalia, in writing the majority decision, said, well, Title VII does not impose a civility code. So the discrimination, if you're going to have sexual harassment, it has to be motivated by sex. But even he found it was motivated by sex because there was a stereotype that the other males had in mind for what kind of person should work on this platform. And this effeminate male didn't fit the stereotype. And so even Justice Scalia said, all right, then that's discrimination against him because of his sex. There's enough of a connection there that you can have a sexual harassment claim. That same reasoning is being used in the courts right now. It's a case before the Eighth Circuit for people who are transgender or who are gay, essentially, to bring claims under Title VII. When Title VII was written in 1964, discrimination because of sex meant male or female. It did not mean that a gay person was protected. And there was old cases that say that. A couple of courts of appeals, the Seventh Circuit in Chicago, the Fourth Circuit, which sits in Virginia, they have said those old cases don't work anymore. Other cases have been decided around the edges. The attitudes in society have changed. So now this sexual stereotyping, where the Supreme Court first recognized that, incidentally, was a sexual harassment claim against Price Waterhouse. And there was a woman who she was not promoted to partner. And they had an evaluation process. Why they did it this way, I don't know, but the evaluation process allowed any partner in Price Waterhouse across the country to evaluate people who were under consideration for partnership. Well, there were a truckload of people that had never met this woman. Some of the evaluations said that she was too macho, she needed to wear jewelry, get her hair done, go to charm school, and I guarantee you she was behaving much the same way as her male colleagues. If she fits the description that she needs to go to charm school, they're not wearing, nobody's telling them that their hairstyle, whatever it is, would make a difference in their professional performance and whether they make partner. So there was sexual stereotyping in the thinking, and the Supreme Court said, okay, that is, in that case, sex discrimination. But in that case, the Price Waterhouse case, that's where that line of reasoning comes. It's now been applied in a broader sense. So I think the Eighth Circuit will decide a case involving a transgender person bringing a claim under Title VII for sex discrimination. And if I were betting, I would bet that they're going to reverse prior decisions of the Eighth Circuit and say because of sexual stereotypical thinking was affecting this employee, that I think it was a male who changed to a female, that she has a claim. So that will probably reach the Supreme Court in the next, 6 months to a year. Stay tuned. I love my job. This stuff, you can't make this stuff up. It is so much fun. And they repeal my education just all the time. What I learned in law school just isn't the law anymore. All right, another situation that can lead to a propensity, shall we say, for sexual harassment is where the workforce has a lot of young employees. They may not be very experienced because they're young, and they may only be in their first or second job. But the young people tend not to know maybe the ways of the workplace like older workers do, and they tend to, shall we say, behave in immature ways. And some of the immaturity of those ways can easily lead to conduct that can be sexually harassing. And then sometimes, most of these cases come up, you get cases involving like, I think there's been some against Burger King, some against McDonald's. They'll bring in a lot of, say, high school age people to work. There'll be inappropriate things going on, and you'll have a supervisor who maybe is 30, who really doesn't know too much about sexual harassment law or anything, and it just gets ignored, or the employee that brings the complaint is just to, get tough, be tough enough. Well, that leads to big problems in this area. But that's the kind of stereotypical place where you have these young, counterproductive behaviors, shall we say. Now, there are also situations in many workplaces where there are certain people who are perceived by owners or managers as being high value. And they may be high maintenance people, but if they say they're in the sales force and they're the ones that can bring in the whales, they may get a lot more, shall we say, berth for their conduct. That doesn't play out well for employers in the long term. It may in the short term. So if there are rainmakers who get the benefit of the doubt and maybe beyond the benefit of the doubt, where people just kind of go wink, wink, nod, nod, and let the rainmaker go, that's a problem. And that's one of the areas the EEOC identified. Another one, it can be a little similar, are where you have relationships where there is a big difference in the power. So frequently, maybe in executive offices, you've got some very high-level executives, and then you have a support staff, and like if you were to use, maybe earnings, and so maybe the people who are in the support staff are making maybe 1/7 or 1/8 of what the higher-level people are making. Those differences in earning capacities also usually show up in power in the workplace. But that's not the only place that those kinds of situations occurs. In plants, in warehouses, you may have a small group of managers, and then you'll have large groups of people who are largely unskilled, low skilled, lower paid, and they are on the losing end of the power disparity. You can also have high status workers who are going to exploit their power to harass low status workers. All right, the example I used a moment ago about someone who brings in the whales, that's typically one of those kind of situations. Low status workers may have little to no understanding of the internal complaint process that an employer may have, and may also fear that complaints will produce reprisals, such as their firing. Where gender differences accompany power differences, such as a male executive group and a female administrative group, harassment occurs more frequently. Another area where there can be more harassment involves situations where there's either tipped employees, so the service industry broadly used. Do you think that the people who work as servers at Hooters don't get harassed by customers? But it's not just Hooters. It can happen anywhere. And I think as Brandon was saying, just because you accept a job at Hooters and you agree to wear the company uniform, I'll call it that, doesn't mean that you can then be harassed by anybody and everybody because of the way you're dressed. You are not inviting it. You're not making otherwise unwelcome conduct welcome. And incidentally, an employer can be held liable for the harassing conduct of its customers. So it's important not to sit by. But it's not only tipped employees. You can have commissioned salespeople. And female commissioned salespeople may be up against trying to close a lot of sales, not only because that's their income, but they may have certain sales objectives, and maybe I'm using the term too loosely, objectives. They may have quotas they have to meet. And so if it enables them to reach the quota by putting up with conduct which is unwelcome sexual conduct, basically, and it doesn't have to be a quid pro quo, it can be hostile environment sexual harassment. Nonetheless, the employer is responsible for that. And you know, how does an employer even know what's going on? Well, we're going to come to the training piece, and Brandon's talked about that. But part of the training piece has to be specific to the workplace. It makes no sense for me to show a video about sexual harassment and all the examples come on construction sites, and I don't employ any construction workers. And my people are out on the field one-on-one trying to sell. I need something that's specific to what the people in my workplace do and what they face in their day-to-day work. And I've had a discussion with many employers and say, boy, if I give that kind of training, I'm going to get a lot of complaints. And I said, well, you'd rather have the complaints where you can deal with them and not have a government agency involved in, you know, if the EEOC were to think there was a big enough problem, they will bring what is a commissioner's charge, and in a commissioner's charge, they will go basically for class relief. You don't want to be in that nightmare. And so you would rather know what the issues are and deal with them before anyone ever goes to an outside party, be it the EEOC, the Missouri Commission on Human Rights, be it a labor union. Although in this state, it's kind of hard to find employees outside of the public sector represented by labor unions outside of the construction trades. All right. Another risk factor are isolated areas. And so if you stop and think, a lot of people are involved. If you are in the service industry and you're doing the, say, in hotels, you're cleaning the rooms, making the beds, you're typically working on your own in a room. And there was a pretty infamous case that happened in New York about 3 or 4 years ago, and it involved I guess he was France's representative at the International Monetary Fund, and at the time he was president of the IMF. Eventually, a housekeeper made a complaint to her employer about his behavior, essentially that he raped her when she was in there to clean the room. Well, housekeepers didn't sign up for that kind of behavior. And employers have to do something about it if it's going on and take steps to prevent it from going on. All right, now you're going to say that there's no fun in the workplace. But the EEOC also said if there are workplaces, and sometimes it's a holiday party once a year, that's hardly a major problem with alcohol, although those one-offs can be a problem depending on what goes on. But in some workplaces, the bar is open every afternoon. When I first started working, like I said, back in the Stone Age, Anheuser-Busch, they could draw beer as they were making it and drink it all day. Talk about a nightmare for a risk manager, but in any case, so in some workplaces, alcohol is much more prevalent than others. And sometimes there's an entertainment factor. And this is not to say that employers need to prohibit all use of alcohol, but they need to be wary and have some limits as to what is acceptable and what is not acceptable, and something that's been thought out in advance as opposed to waiting for some disaster to happen. Decentralized workplaces. What the EEOC is talking about with decentralized workplaces are places where there's very little contact, at least directly, between these facilities and maybe corporate headquarters. And so maybe it's a distribution center, and maybe it's a business. If you're Amazon now, you have distribution centers all over the country. And I don't know about what Amazon's management structure is, but a lot of times at a local level, at a certain level, there's not much going on. There's no one that does HR at those facilities. There's no direct contact with an HR department for the corporate offices. If I work in the warehouse, I don't know who I contact. Generally, it will be someone at the facility. The people at the facility tend to say, we need to handle all of our problems here. We don't need headquarters intervening. That can be a big problem, especially with something like sexual harassment, where it's usually corporate offices are more in tune with what the business needs to be doing than a local office that is willing to usually cut slack to other people within the group that control the local facility. All right, so we've been through all of these identifiable risk factors. What is it an employer needs to do? Well, one thing, and I don't want to digress too far, and I don't want to go too deep in the weeds about the law for you, much as I love to do that, but there are two Supreme Court cases that were decided in 1998, and they came up with something that one case was brought by a woman named Farragher, and it was against the city of Boca Raton. Another one was brought by a woman by the name of Ellerth, and she brought it against Burlington Industries. Both were hostile environment sexual harassment cases. And what the arguments of the employers were in both cases was they weren't responsible for the conduct that was at the bottom of these complaints because the employer didn't know about it. And the Supreme Court got into this discussion about agency law. And gee, when do you know? Well, let's distill it down. Somewhat what Brandon was saying, if you know, it happens in front of your eyes, so you know that sexual harassment's going on, that's hostile environment, you see the jokes, you see the pictures, if you know about it, you're responsible for it, you can be held liable for it. If you should have known, but didn't know, you're still responsible. So playing ostrich does not work in this area of the law. What the Supreme Court came up with was this Farragher-Ellerth affirmative defense. There's two branches of it. And the first branch is the employer needs to have an explicit policy that prohibits sexual harassment. It needs to communicate the policy to its employees, and it needs to have some way for employees to bring complaints. Because part of the goal of Title VII is to prevent unlawful conduct. And so what the Supreme Court's reasoning was is if employers are trying to prevent unlawful conduct, unlawful sexual harassment, and it's occurring despite those efforts, then there may be good reason not to hold the employer responsible. So that's the first prong. The second prong goes back to the person bringing the complaint. If the employer can show there was some kind of complaints procedure and the employee bringing the complaint did not use the complaints procedure, then the employer has proven the affirmative defense and will not be held liable for at least hostile environment sexual harassment. Hostile environment sexual harassment, more or less by definition, cannot affect a tangible aspect of employment. By that I mean job loss, pay cut, a failure to promote. Generally, the Supreme Court said anything where the employer documents it in paper, and those are usually critical decisions. Those are tangible employment actions. And so if someone's complaining about things that really don't get documented, discussions, okay, that's probably not enough if that's the adverse action at the heart of it. So this affirmative defense is what led to all the training on sexual harassment, because there was this incentive then put forward by the Supreme Court for employers to do something affirmative to try to prevent unlawful conduct. And they could be rewarded if they did that, and of course the employee didn't bring a complaint in the process. So 1998, that means we had 18 years where it was optional, kind of optional to do sexual harassment training. Some employers did it, some didn't. 1998 till now, almost all employers do it in some fashion. Some do it in much better fashions than others. And the point, I think, of our conversation today is to try to find ways to do it in a better way, because at least when the EEOC looked at the landscape, it said overall, it's not very effective, the training that's being done. The other thing that we always have to keep in mind is this complaints procedure piece. On the complaints procedure, it's fine if you do some, you don't have to have any particular procedure. You can even have a simple open door procedure. Or you can have something more formal with steps and going through with different people involved and different levels. But you have to have an open mind on the other side of the open door, or an open mind doing some kind of complaints procedure. If you don't have an open mind, it's not going to work, and employees aren't going to use it, and employers aren't going to get the benefit of the defense. And in order for a complaints procedure to be effective, employees have to understand that they've been heard. Sometimes they don't even have, they can take it much better if the employer basically does, and I've been involved in many investigations, where it's he said, she said. You interview everybody in sight that was around where the alleged conduct happened. You document all that. But at the end of the day, it's he said, she said. Well, when you reach that point, you say, well, we've reached inconclusive results. But here's what we're going to do. You don't end it there. Say, with the inconclusive results, you sit down with the person where there's an allegation against, let's just say him, and you explain this is what our sexual harassment policy is. Don't know how you could have missed it. By the way, sign off. You just read it in front of me. And we don't know, our investigation was inconclusive, but if you were to have more complaints like this in the future, that's not a plus. Because where there's smoke, there's fire. A word to the wise suffices. Then you sit down with the complainant and essentially say, the results were inconclusive. Is there any more? Here's basically what our results were. Is there anything that you know that we should check out, which we haven't done? Generally, they'll say no, but if they come up with something else, you continue the investigation. At the end of the day, if it's inconclusive, you say, well, it's inconclusive, so what we will do is we will be in touch with you after 30 days, 60 days, 90 days. Our policies prohibit retaliation. You are to come to us immediately if you experience any retaliation. And we're going to have this follow up with you and proactively make sure that nothing adverse is happening to you as you understand it. That's about as good as you can do in that situation. And in my experience, probably far more than 80% of the investigations end inconclusively in this area. But if you do have someone who is a, shall we say, serially alleged perpetrator, as I said, most employers don't. You get cut slack once, you're not going to get cut slack after that. And it's just too much at risk, and no matter how valuable an employee is. Other things that could be part of the system to help make it work better, you certainly don't want a complaint system where the employee bringing the complaint has to go to the alleged harasser to make the complaint. So there must be alternative ways to make the complaint. Some employers use 800 toll-free numbers, some use online services. Those are fine. Several people within the same organization. The most important thing is to have a way to capture the complaints and then to do something. If you get a complaint and you don't investigate it, shame on you. I mean, you've lost an opportunity. And if you do the investigation right, even if you come up with inconclusive results, usually the employee that brought the complaint is impressed that you went to the lengths you did to investigate it and that you're trying to be fair. The other thing that comes up frequently is, well, how confidential can this complaints process be? Well, another agency, the National Labor Relations Board, made that really difficult because in interpreting the law under which it operates, the National Labor Relations Act, Section 7 prohibits employers from interfering with the collective concerted activities of their employees. And that's been interpreted to mean that employees have a right to know about and complain about their working conditions, which would include hostile environment, sexual harassment, and, for example, here, we'll do a quick poll. How many of the employers in this room have a rule that prohibits employees from discussing what they get paid with any other employee? All right, not that many. Usually I get at least half the room. That's a per se violation, in other words, automatic violation of the National Labor Relations Act, because you're prohibiting an employee from engaging in protected concerted activity, such as asking about how much they get paid. All right, but the same rule applies in a sexual harassment. So what you typically do is you tell the employees that no one on management and no one involved in the investigation will be disclosing anything about the investigation other than on a need-to-know basis, because let's face it, if you're interviewing people, you're going to have to ask whether they were there at a particular time, place, and manner. And you can ask them, what'd you see? And when they come back and say, I don't remember anything, then you're going to have to follow up. Well, did you see this? Which are basically the allegations. So to do an effective investigation, you basically have to tell people what the allegations are. No ifs, ands, or buts about it, or you're not doing an effective investigation. So the people who are getting questioned are going to know pretty much what the alleged conduct was. And they're going to talk. It's a fact of life. You can encourage them not to talk, you just cannot prohibit them, and you cannot discipline if you know they do talk about it. Another question that comes up, what about anonymous complaints? Most of the time in a complaints procedure, you have to come forward and identify who you are to make a complaint. And maybe you have someone who comes forward and says, I don't want you to identify me as a complainant. What do you do with that? Well, there's not a whole lot of case law on that, but I think the prudent thing to do is tell that person, if we have to treat you totally anonymously, we will not be able to do as thorough an investigation as we would if we could identify who you are when we're doing the investigation. We will still investigate as best we can, but it may affect the results of the investigation. And then you go out and you do it, and you do circle back to that person, and you do present the results. And maybe that person will change her mind if she sees that you've treated the complaint seriously and that it looks like you want to do something about it, but you need more information, and maybe not. You do the best you can. When I'm standing in front of juries, I say, you can't, employers aren't perfect. So my client wasn't perfect, but my client acted in good faith. That's all you have to do. And in any case, the other piece of this is make sure that you have a robust anti-retaliation policy and that it is communicated as part of what the complaints procedure is. And be serious about it. Now, what you will frequently face in a workplace where sexual harassment occurs is no complaints, no big surprise when you see that only somewhere between 6 to 13% of victims actually either go to management or the EEOC. So that means, 77%, 87% aren't complaining. So, but there are open secrets. Everybody kind of knows, or there's rumors. Fine example was, at least in the newspaper accounts I read about Charlie Rose, these interns would ask each other, well, has Charlie asked you to bring some paperwork to his apartment? And have you gotten the full Charlie Rose treatment? I mean, they knew what was going on, okay? And that happens in every workplace. And sometimes you look at things. I had a situation, and that's probably 20 years ago now, but there was a guy it was a retail business, he was a regional manager, and he visited a lot of retail locations. And forever, he had put his arms around, there usually were, in the area some of his subordinates were female, he'd put his arms around them and he would kiss them when he visited their stores. Finally, someone complained and said, well, this is unwelcome. I don't want him putting his arm around me and kissing me. He ended up losing his job. He had done his job the same way for 20 years preceding that, but the times had changed. And in many ways, the employer let him down for not doing the training necessary with management so that management understands what is and what is not acceptable conduct. And then the other thing for a complaints procedure, if the investigation confirms that the sexual harassment policy has been violated, and I always phrase it that way because the employer's policy doesn't have to be identical to the law. So the employer, if it wants to expand the policy to, say, questionable conduct, it certainly can. And it might be wise to do that to avoid encouraging more encroachment into clearly impermissible conduct. But if the investigation confirms that there has been wrongdoing, then corrective action must be taken. This is a punishment should fit the crime. Doesn't require capital punishment. There can be an employee who has violated the sexual harassment policy and gets some kind of disciplinary action, depending on something that is fairly innocuous. Maybe you start through a progressive thing with oral warnings, written warnings, that kind of thing. The word egregious does appear in case law. I know Raymond used that. Egregious, typically, you would have to have physical contact involved at a minimum. Most of the case law that are recognized as a single act egregious involve assaults. So slapping somebody in the face, grabbing by the wrist, maybe not, all right? But in most of this hostile environment sexual harassment, it's not a single incident, it's ongoing conduct. And what's interesting is the conduct has to be unwelcome. And how do you judge that? Because if I'm the person that the conduct is directed at, my subjective view of what's unwelcome conduct, I could be the eggshell person, and if you smile at me, I think you're coming on to me. And then there's another standard that's objective. It's supposed to be the reasonable person, and the way that the Supreme Court has defined it in its case law is the reasonable person in the position of the victim. So it's not the reasonable male, what goes along with the person maybe that is doing the conduct, but on the receiving end, what that reasonable person. And what that is supposed to filter out is these eggshell people who can see unlawful, unwelcome sexual conduct in anything and everything from what's reasonable. Oh, one more pointer. It's probably a worthy activity, shall we say, not required by law, but to do employee surveys from time to time. And in the surveys, particularly address issues regarding sexual harassment to see how effective your training is and how comfortable employees feel about bringing complaints, whether they think the complaints are handled effectively. And then if the results of those surveys show that maybe management sees things much differently from those who are being managed, that's probably a big sign to go out and make some changes, and to change your training and maybe do more. All right, the EEOC, in concluding its sexual harassment evaluation, said, maybe the problem with the training and things is that we need to go beyond in things that aren't necessarily prohibited by law. So they raise kind of two things. One is they encourage employers to do civility training, kind of like anti-bullying training. And what the EEOC pointed out is that it's not unlawful to be an equal opportunity jerk, all right? So, I can go in the workforce, and as long as I put my arms around both males and females, and I kiss both males and females, you can't touch me under sexual harassment, all right? But you might say, we don't want that going on in our workplace. And that's not the example we want set in the workplace. And so what the EEOC is saying that employers ought to consider these things because frequently the conduct, it's kind of, remember math class and Venn diagrams? And you can usually take hostile work environment sexual harassment, and you can usually take a small circle and stick it into bigger circle. It's just a smaller part of this power dynamic that goes on in bullying in one form of another. And so if you combat bullying, you are also combating just about all forms of hostile environment sexual harassment. And another piece of advice from the EEOC is in doing the training, there should be more than kind of, here's all the things you cannot do. Don't do this, don't do that. You need a positive message. And the positive message can really come through in the civility training part of it. Well, this is the expectation this employer has for conduct in the workplace. This is how we treat each other with dignity and respect. You can say a lot of positive things about that. And the other thing, as I conclude my remarks, that the EEOC advises, not required by law, but is bystander intervention training. And the EEOC said it's taking a page from what has been done on college campuses where under Title IX, which is a different discrimination law, but colleges and universities that get any kind of federal money are required under Title IX to prohibit any kind of sexual harassment, and it can be student to student. And so what schools have done is this bystander intervention training where they're saying, well, let's create more awareness so that bystanders can recognize there's problematic behavior occurring. And then the training also instills a sense of collective responsibility that motivates bystanders to step forward and take action when they see problematic conduct. Training includes skills building exercises to give bystanders the skills and confidence to intervene as appropriate. And finally, it identifies resources available to bystanders that they can access to support their intervention. So it's kind of create peer pressure which doesn't tolerate sexually harassing behavior, essentially. You have to distill it. Those are my prepared remarks. I'd love to have questions. Questions are more fun than me rambling on. Even though it may sound like I like to listen to myself. Yes, ma'am. The question is, what do you do if you have a vendor and does the vendor send a person to your workplace? You said it was a vendor. Is it a vendor sending people to your workplace? Or? Okay, vendor comes in the workplace, it's a copy guy or whatever. And if there is a complaint about the vendor's representative's behavior that is sexually harassing, so what do you do about it was one part of it. And then what if the employee's not happy with what you do about it? And all right, well, it seems to me your company is in the power position with the vendor. The vendor wants your business. You tell them to get somebody else to take care of it. Now, you don't have to start there, but what you essentially do is follow your complaints procedure and contact the vendor and say, we have this complaint, we need to talk to your employee, find out. And, at least when I do investigations, usually in the same workplace, I want everybody's personnel record for me to look at as part of it. Now, they don't have to give you his personnel record. It could be very interesting if there's been other complaints like this made against this guy. Would tend to give credibility, I would think, to the current complaint. And, are there liability issues for the employer? Let's say you do the investigation, you conclude the vendor is responsible for harassing your employees. Then at that point, you contact the vendor and say, your current representative is persona non grata here. You send us someone else or we'll replace you. You don't have to do business with vendors. You have no liability to them. Now, you may have the guy, the vendor rep, who's claiming this is all false, so I'm going to sue you for libel and slander. I wouldn't worry about it. Nobody does that. Libel and slander is very hard to prove. I mean, it's goofiness. I can only think of one person that has filed libel and slander suits against adversaries, and he's always settled. He now lives in 1600 Pennsylvania Avenue, but whatever. Yes, ma'am. Okay, the question is kind of the flip side, where employer sends its employee to other workplaces and the employer's employee does his job there. And someone at the customers, essentially, one of the owners is female and made unwelcome sexual advances to this male employee, and then he made a complaint, as well he should. I would say, well, always follow the same. You got a complaint, so you contact them and say, hey, we have this complaint. We need to talk to whoever it is that's responsible, and if he identifies other people there, and see what level of cooperation you get. Again, if your employees are being subject to sexual harassment by some other business, you don't have to continue doing business with that company. And what you also face when you start reassigning people when they're the complainant, boy, you open yourself to a retaliation claim. Now sometimes you're not going to get it. If it all pays the same, the hour's the same, suddenly you're not sending the guy off to Siberia to do his duties or whatever. Okay, it might not be a problem. It can be a problem to think the simple solution is to separate the two, and the easiest person to move is the one bringing the complaint. That's generally an ill-advised step. Wow, we've exhausted the questions. Go ahead.
You talked about the fact that you historically have worked on non-disclosure agreements and also the fact that the law has changed quite a bit since the Stone Ages. So do those still carry as much clout as they once did? I don't mean to politicize this with obviously everything going on in the news now, but it seems as though people are finding ways around them outside of a lack of signature and the obvious loopholes. But do they still carry as much clout and should they be used?
Well, here's what I usually tell when I'm writing an agreement, we're settling a claim, and I tell the employer, we'll put this in, call it a confidentiality provision, and we'll put liquidated damages, not millions like the notorious agreement we have, but it will be, if the settlement is $50,000, we'll say an amount equal to half the settlement. And write it in such a way that each violation is a separate liquidated damages. I will tell the employer, I don't think any court will ever enforce this, liquidated damages, quite honestly. You put it in to put the fear of God in the person signing it. He or she will tell certain people no matter what, but he's probably not going to tell the world. Now, in the last couple years, there's been litigation that I've seen, and I know the Sixth Circuit, a U.S. Court of Appeals that sits in Cincinnati, enforced an agreement where the entire amount of the settlement, it was like $120,000, was the liquidated damages, and he wasn't supposed to say anything. And the night the settlement was, the ink wasn't even dry on the agreement, his daughter went on the Facebook and said, "We're going to Disney World! My dad just settled his lawsuit." So the guy never got his money. All right? Now, I would fully expect people to tell a spouse. Maybe not a good idea to tell your teenage kids, because Lord knows what's going to happen with it. And I still kind of believe that the liquidated damage thing is more a put fear in people. And most of the time, it's a big issue at the time you're doing the settlement, and it becomes a zero after that. And the farther the time goes out, the less important it is. Same thing with the non-disparagement, no bad-mouthing provisions. Sometimes you fight tooth and nail over those. I've never seen anybody go into court to try to enforce it.